Hey everybody, friend. It's Eric Carter-Landin, the host and producer of True Consequences podcast. This episode I felt was really important to finish telling some of the story about the trial. I wanted to share the closing arguments from the defense as well as the prosecution. My name is Eric Carter-Landin, and this is True Consequences, Negligence, the Dylan Redwine Story. Welcome back to part.
My presentation doesn't start in Biofito, doesn't start in Colorado Springs, doesn't start in Durango. It starts in Bakersfield, California. There's a crew out there working for United Pipeline. Crew leader, the man charged in this case, Mark Redwine. He's in his truck away from the men that he's supervising. And I think it was evident in the testimony that working in the fields for United Pipe attracts and employs a rough and tumble sort of crowd. And that's okay. The leader of this crew in Bakersfield on a hot summer afternoon, he's not screwing around with his coworkers. He's not getting up in their business. Not making sure the pipelines are running correctly. He's in his truck, looking at his phone. Pictures of the sun. Who he's estranged from. Who he doesn't have a good relationship with. Who he's losing. He's looking at the pictures of his son. Playing ball. And he's weeping. And he can't help it. He's working in a place where show of emotion, crying over a cell phone is not what you do and is not generally socially accepted. And he's crying when he's looking at these pictures of Dylan Redwine because he loves him and he misses him. And Freddie Crasium, you heard him testify yesterday, he sees this man hovering over his phone, over the pictures of his son, weeping, because he loves him. Many, many months down the road, years, he sheds those same tears, and Tom Cowling tells him they found Dylan's name. He loves Dylan, misses Dylan. He wants Dylan in his life. And as the prosecution says, use your life experience, use your common sense. If you want one of your children, your son, your youngest son in your life, you don't kill. You bring him into your life. That's what Mark Redwine. Even using their analysis, the Occam's razor, what's the simplest answer to what's going on here? You want your son in your life. If you want a relationship with them, you don't kill them hours after they arrive to come visit you. I'm going to ask you to reflect on the evidence in this case, the lack of evidence in this case. And on behalf of Mr. Redwine, I'm going to ask that you return to not guilty verdicts. Not guilty of murder in the second degree. Not guilty of child abuse resulting in death. The not guilty verdict from this case flows from the evidence in this case, the lack of evidence in this case, science, the testimony, and the not guilty verdict flows from what you know about this case now. You guys have become experts on what's going on in this case, more so than probably a very small number of other people in the world. And it's what you know about this case, not what the prosecution wants you to think happened in this case, not what the prosecution wants you to speculate about what happened in this case, but what you know from the evidence and lack of evidence. Justice and the verdict in this case should flow from truth and facts and science. It shouldn't flow from hatred, disgust, bias. It shouldn't flow from speculation, innuendo, or unjustified interest. The verdict in this case should not flow from what you think might have happened. You're confined to the evidence and reasonable inferences therefrom. I listened to Mr. Doherty talk. I didn't count them all, but I heard him say these phrases a lot when he was addressing y'all. A lot of the time, he'd say, maybe it was this. Maybe this happened in the living room. Maybe this happened in the living room. You think maybe this happened. You think this happened. I can't tell you what happened in the living room November 18th, 2012. After 9 years, 5 weeks of trial, all this investigation, they can't tell you what happened. He said, can you imagine? Can you imagine if this happened? Can you imagine if that happened? Can you imagine if he said, F you? Can you imagine if he said, hey, shit-eating shit-eater? Can you imagine that? Or what if this happened? What if this happened? Maybe this happened. When someone's on trial for murdering their youngest son, and the prosecution's thesis is what if, or maybe, or can you imagine? That's a window into how weak the evidence is in this case. When the thesis of the government is, can you imagine? What if? Maybe this happened. When they're starting off with maybe, your deliberations end with not guilty. These are the bullet points that I want to talk about while I got your attention this afternoon. As I've listened to the testimony and looked at the evidence, I submit to you respectfully. The government's case is based upon the manipulation of science, targeting someone, in this case, Mr. Redwine. It's easy to hate and dehumanize. Their case flows from a biased investigation and an impossible timeline. And I'm going to talk about each one of those in turn. And I'm going to beg your patience while I do all that. But before I get into that, I got to talk about some other stuff first. One of the instructions you got from the court, and we talked about it during jury selection, was beyond a reasonable doubt. And as you can read, and you actually have this instruction in your binders, the doubt based upon reason and common sense. That's why we use the term common sense a lot during closing and opening arguments. It comes from a fair and rational consideration of all the evidence, lack of evidence. Reasonable doubt is not vague, speculative, or imaginary doubt. It's such a doubt as would make reasonable people hesitate to act in a matter of importance to themselves. We talked about how this is lawyer talk, law school talk, all during jury selection. But it's the lack of evidence, the evidence itself, the uncredible evidence, makes you hesitate during your deliberation, at the conclusion of your deliberation, if you are still hesitating, as you would in a matter of importance to yourself, then the verdict is not guilty. Reasonable doubt resides in that hesitation you feel in your stomach, in your mind, when you think about the gaping holes of evidence in this case, and how the prosecution's theory in this case runs contrary to science. It's that hesitation you feel in your mind, in your heart, in your stomach. beyond a reasonable doubt. And I don't even think they can get this far. I mean, you think, well, I don't know, maybe he did it. If your consensus is maybe he did it, the verdict is not guilty. Well, I don't know, he's the last person to see him according to the prosecution, and, you know, Dylan was walking 2 feet away from him at the airport, so he probably did it. Probably. He was not guilty. Well, you know, they called this one human remains detection dog expert, and they called the other one. I don't know what happened. You don't know what happened? That's not guilty. The thing about reasonable doubt is that doesn't have to be unanimous. Reasonable doubt can be something different for each and every one of you. Reasonable doubt can be the fact that the most overwhelming evidence of injury to Dylan Redwine is animal scavenging. For another one of you, reasonable doubt may be the absolutely underwhelming, pedestrian, unremarkable DNA evidence in this case. Another one you might have reasonable doubt because you just don't think that dogs can tell people that though something is not there right now, that thing was probably there about 110 days ago, based upon the way the dog sits and looks at its owner. Reasonable doubt might be there was DNA from another man found in the vicinity, in the same place as the first set of remains. You guys don't have to be unanimous in reasonable doubt. It can be something different for each and every one of you. Philosophically, reasonable doubt flows from the government being unable to produce to you any sort of weapon. Reasonable doubt flows from the government being unable to articulate to you over 5 weeks what the cause of death is. Reasonable doubt flows from the fact that there's no evidence of a fight, that there's no evidence of cleanup, there's no credible evidence. And we'll get into this. I got the afternoon. There's no credible evidence of motive. Reasonable doubt flows from the fact that nobody on the day after hunting season was over, when there's a lot of traffic in that part of the world, nobody saw Mark Redwine drive to that little neighborhood up there by the campground, go to the general store in Valsita, take a left and drive up Middle Mountain Road. And reasonable doubt also flows from the fact that the government, the prosecution, the attorneys from Boulder and Durango still can't provide you an explanation of what happened. So as you look at the evidence in this case, as you look at the science in this case, as you look at the lack of evidence in this case, as you look at the credibility of certain witnesses, you are obligated, as the court has armed you with this instruction about reasonable doubt, to see it through that filter. This is what the government has provided you with. You've heard testimony there was a bad divorce. We'll get into that. But Dylan did not want to go to Vallecillo. The pictures. Walmart. He had plans to see his friends. Still more stuff about the pictures. You've heard about the baseball road trip. The front porch light apparently being on at 2 o'clock in the morning. That he was Dylan was almost habitual texter. They provided you all this prequel, and they provided you this information. 1.9 nanograms of presumptive blood. That's the one portion of biological material in the living room that's not a mixture. That's the one that was a match to Dylan Redwine's blood. And as we know, 1.9 nanograms is 1.9 billionths not billions, billions, TH. 1.9 billionths of a gram. They presented you a normal-looking living room. Evidence that the postcranial remains were scavenged. Provided you evidence. Cranial fractures, cranium, skull, bone. Cranial fractures consistent with taphonomy, which means natural causes. They provided you with 2 minuscule, thinner than a millimeter, marks on the zygoma. And they also presented you with testimony of dogs making their owners happy in the form of human remains detection dogs. What they have not provided you with, the 0 here, is what they think happened. It's what happened. And as they said, as Mr. Doherty said, he can't tell you. And if the government, the prosecutors, but the La Plata County Sheriff's Department, Federal Bureau of Investigation, Colorado Bureau of Investigation, National Forest Service cannot tell you after 9 years what happened because they don't know. If they don't know, you don't know. You may not like the pictures of Mr. Redwine. And you may not approve of the way he handled himself during the search for his son. And you may not approve of the way he handled himself during the divorce. You may not approve of a lot of things he does. But if they don't know what happened, you don't know what happened. If you don't know what happened, regardless of your opinions of the defendant and how he comported himself while his son was missing and dead, you must return verdict of not guilty. The verdict form does not say, do you approve unanimously of how this man acted when he found his son was missing? The verdict form does not say, do you approve of the way this man spoke to his other son, Brandon? The verdict form doesn't say, unanimously, would you, as loving parents, children, family members, have done something different? The verdict form is limited to the crimes they charged him with. The verdict form is limited to the story after 5 weeks that they cannot tell because the evidence does not support a guilty verdict. And they've even told you, we don't even need remains. We'd be here even if there weren't remains. We would go on innuendo and these facts alone. That's good enough for us. We'll get into the bias investigation in a little while, please. Point being, you got to know what happened to convict. If you're going to convict someone of killing their youngest son, you have to know what happened. And if you don't, without hesitation, you must return a not guilty verdict. As I understand the government's case, there's 5 parts. The father, Mark Redwine, the drunk, cross-dressing, feces eater, with homicidal rage about his proclivities. They allege his youngest son, Dylan, confronted him about the cross-dressing, feces eating. So he killed his youngest son, decapitated him, dismembered him, and spread him around the hills with pathological surgical precision. To navigate to a guilty verdict, you've got to buy into all 5 parts of that. You got to buy into all 5 parts of that. You have to buy into that as you look at the elements of all the charges here and buy into that beyond a reasonable doubt without hesitation. If one part of those 5 parts doesn't work for you, that's not guilty. And as I'm going to talk about here in a minute, their theory defies reality, facts, science, and common sense. You don't have to be a scientist to get to not guilty here. You just got to have common sense. Science kind of helps a little bit, though. Common sense begs the question here. Is there more evidence of a young boy leaving his house, an animal predation and scavenging, or is there more evidence of this unsubstantiated, ghoulish fantasy that the prosecution has posited? When you look at the evidence, right, when you look at what was found, what wasn't found in Middle Mountain, what was found, wasn't found in the house, Is there more evidence of animal damage, or is there more evidence of this ghoulish, creepy beating pictures, temper tantrum, killing, decapitation, dismemberment, driving into the hills, spreading dead body parts all over the Alcida? I mean, that's not a bad place to start your inquiry. What do we got here? Targeting a defendant is easy to dehumanize. Why is it easy to dehumanize? Government case. Is it easy to dehumanize Mr. Mark Redwine? Yeah, they got the pictures of him eating feces out of a diaper. Well, cross-dressing. Posing, taking selfies. That's pretty easy. Is there any credible evidence about him having a homicidal rage about the pictures? I submit to you, I'm going to talk about it in a while. No. Is there any evidence, as you reflect back on what you've seen and heard over the last 5 weeks, is there any evidence Dylan confronted him about the pictures on November 18th? I submit to you, there's no evidence he killed his son. We'll get into that in a second. Is there any evidence that a man who works as a supervisor in the oil fields for United Pipeline has the know-how and ability to decapitate, dismember his son, clean up the entire place where they think this happened with surgical pathological precision, and then take those body parts, spread them out all over the area outside of Alabama? Is someone capable of doing that, given their education and experience? And I submit to you, there's no evidence. You could have been able to do that. Please. So we have the government's case is based on the pictures. They introduce the pictures as evidence. They want you to believe that these pictures will provide some enlightenment to you about the motive that they ascribe to Mr. Redwine for killing his youngest son, whom he loved. They introduce these pictures, but they don't want you to look at them. I'm going to show them to you. Do not fall for that. The prosecution likes these pictures a lot more than they like the tangible and scientific evidence in this case. They like those pictures more than they like the fact that uncontested damage by animals to the remains. The marks on the cranium are consistent with animal damage. They like those pictures better than the fact that the DNA evidence is contradictory and underwhelming. They like those pictures better than the dog alerts being unscientific, that the timeline makes no sense, and that there's no facts in hand as you go to the deliberation room to support some sort of picture compensation theory. Use your common sense. Keep going. I did a lot of stuff. When you go to the deliberation room and you reflect on what the prosecution has said about motive, if you acknowledge there is no testimony and no evidence that on or about November 18, 2012, that Dylan confronted, questioned, asked, heckled Mark Redwine about the photos, if you acknowledge that that evidence does not exist in the record that flowed from this witness stand, if you acknowledge that there is no evidence of that, if you acknowledge that that motive, that we think that maybe Dylan, a 13-year-old boy, and we're not going to say he was the only 13-year-old boy who was having a difficult time with his dad. You think to yourself, well, we think that Dylan was a 13-year-old boy who was having a difficult time with his dad, didn't want part of that relationship, and either told his dad, fuck you, shit-eating shit-eater, I don't like you because of these pictures, you're a bad dad, don't talk about my mom that way. If you think that maybe he did something like that and that triggered his dad to kill him some way or another that we can't define, if you acknowledge that there's no evidence, there's no there, not guilty is the verdict. You must return without hesitation. comes back to what they would say is the theme of Mr. Bogan's presentation. Are you going to rely on evidence? We'll get into the evidence in a minute. Or are you going to rely on speculation? The speculation being, according to the two women who went to Mr. Redwine's house, on the same day he found out definitively that Dylan was dead, and yelled at him from a car and drove up right to the property line and started yelling at him. Do you believe them when they say that when you call out Mark Redwine for being a shit-eating shit-eater, he goes in homicidal rage, he kills you? So is that what you want to hitch onto? Or do you want to look at the evidence and science and lack of evidence in this case? And I submit to you, I think it's pretty obvious what I'm asking you to do. I'm asking you to look at the evidence. I'm asking you to think about the testimony. I'm asking you to think about what we are actually dealing with here, and not the raw emotions of a community and family getting absorbed by the tragedy of Dylan going missing and Dylan's death. The magnitude of the violence they are talking about and the magnitude of the cleanup they're alleging could not be conducted a forensic pathologist, much less someone with no medical training. And they're going to come back and say, well, bodies don't bleed a lot after they're dead because the hearts stop beating. Use your common sense. They're basically alleging that Dylan was cut into pieces in that living room. And that when we boil it down to what they have in this case, to loop back with whether or not your deliberations, your opinions, your verdicts flow from evidence and science, you have 1.9 nanograms of Dylan's blood in the living room, 2 tiny marks on his zygoma that are better explained by animal scavenging. You got a dad who may have not acted the way you would have acted when his son went missing, but they are creating this narrative about rage and anger and photos and deteriorating relationship, and they want you to latch on to this story because the actual physical evidence in the case does not support that Mark Redwine killed his son. And I ask you to focus in on what you know, what you've heard, science and fact, and to not get washed downstream by bias and emotion and everything else. Take a hard look at what you've heard in this case, what you have and what you don't have. And if your deliberations are colored with uncertainty and hesitation, you're not detectives, you are jurors. If your deliberations are colored by hesitation and uncertainty, the verdict should be clear here. And that verdict flows from evidence, not from everything that's around it. That verdict should flow from what you've actually experienced in this courtroom, not statements like, could have, do you think, maybe, we can't tell you, could have. You breathe life into the instructions the judge has given you and what you've heard in this case. I believe the verdict will be apparent to you. And there's a reason you wound up in this room on the stage. Find them not guilty.
Here's the first thing I'm going to ask you to do when you start to deliberate. Defense counsel told you exactly what happened in that living room. You must find the defendant not guilty. So please do this with me when you go in the jury room. Look in the jury instructions. Don't rely on counsel. Don't rely on me. Rely on the judge and rely on the law for the state of Colorado. You won't find that anywhere in that book because it doesn't exist. And if it did exist, we'd have a heck of a lot of murder cases never happening because the victim dies. That's why the law doesn't require the prosecution to tell you the blow-by-blow activity of what happens in this living room or in any murder case. So when defense counsel tells you that if the prosecution can't prove exactly what happened in that living room, you're required to find the defendant not guilty, check the law. It's totally 100% false. And for good reason, because the victim's dead. The victim is dead. So in murder cases, you never have the victim. But we have the evidence, and we know exactly what happened in the living room. The defendant killed Dylan Redwine. That is what happened in that living room. The defendant is guilty of killing Dylan Redwine in that living room. Defense counsel held up for you exhibit number 1, a fishing pole. It's a fishing board. It's not the fishing pole. It's in the spot where the pole would have been and should have been and was until the defendant removed it to make his story about Dylan going fishing sound good. And boy, oh boy, he would love for it to be in the book right now. But that's no fishing pole hanging from the hook, ladies and gentlemen. Because when law enforcement showed up to search, and FBI agent Russin went under the ATV and searched the whole garage along with the rest of law enforcement, the defendant had taken the fishing pole. So look at that picture yourself. It's not a pole, it's a lure. Defense counsel started talking about the debit card and highlighted the debit card ended up being deactivated because Dylan tried to get into the account a bunch of times without having the right PIN number the defendant hadn't given to. And you're left wondering, why did the defendant have the debit card? Dylan had it on November 18th. How does it end up with this guy? And it's because he took it off of his son after his son was dead, along with the rest of his belongings. And you're left wondering, well, the card might be deactivated, but why did he empty his son's account before the remains had been found? Because he knew his son was dead and would never be able to spend a single cent, including the 6 cents left behind when the defendant took out the $2,000 on January 28th, 2013, before the remains were found. He is guilty of murder, ladies and gentlemen. Defense counsel wants you to believe that this was a rushed and biased investigation. The murder happened in 2012. The investigation was a painstaking, hard-worked, outstanding investigation that went on for years. And the La Plata County Sheriff's Office had the dedication, the commitment, and the humility to bring in the FBI, CBI, to talk to experts all around the state of Colorado, including Dr. France and Dr. Kurtzman, to do their very best, starting with, how do we find Dylan? Because although he made no effort, and he made no calls, and he made no text, there was a lot of people who wanted to find Dylan Redwine, including the La Plata County Sheriff's Office. Charges were filed in 2017. This is no rush to judgment, ladies and gentlemen. This is putting together a circumstantial case against the man that killed Dylan Redwine. It was an extremely thoughtful and dedicated investigation. When they talk about the investigation in their closing, I ask that you remember, it comes down to this. The man who did everything to cover his tracks, the man who put his son out in the woods to be eaten by scavengers, now wants to benefit from the destruction of evidence that he left behind. He wants to benefit from leaving his son in the woods to be eaten by animals. And then to stand up in front of you and say, you don't have enough now because I left my son there to be eaten by scavengers. And he wants to benefit from that? He doesn't get that benefit. Not when there's enough evidence to convict, ladies and gentlemen. So he can stand up all day long and say there's not a lot left. But there's enough left to know exactly what he did. What happened in the living room? The defendant murdered a 13-year-old boy. He murdered a 13-year-old boy and did everything he could to dispose of his remains. The experts upon whom you can rely in this case, Dr. Kurtzman, who found it to be a homicide, along with Jan Smith, the coroner, who agreed with Dr. Kurtzman, Dr. France, who one point I would highlight from the defense closing, she testified, and you've been taking notes and paying such incredibly close attention, so you remember this. But she testified that if the skull had been fractured close in time to when it was found, that fracture would have been a completely different color. She believed it was blunt force trauma and that the cuts were inflicted as sharp force injuries by another person. One of the amazing things about these experts and why the idea that Dr. France destroyed evidence is completely contradicted by the evidence, her testimony, and common sense, is that they come in here and they don't take a position of 100% certainty. It's not how scientists operate. They say it's more likely, very unlikely. That's the world they operate in. That's the reason you should trust them. That's why when they say to you, it's very likely that it's blunt force trauma that hit him here, and Dr. Kurtzman says it could have caused his death, and I determined, Dr. Kurtzman, it's a homicide. Dr. France, counsel wants you to believe she destroyed evidence intentionally. You know from the defense expert Eric Smith, two-mark analyst, that casting the skull for two-mark analysis is a normal process. It's what Dr. France should have done. She is an expert. You heard her testify. She's an amazing woman, quite frankly, and a great, great forensic anthropologist, and well-respected throughout the state of Colorado, which is why Dr. Anderson admitted you want to have someone from the region look at the evidence. And when Dr. France looked at it and she did the molding, she then disclosed to the sheriff's office, the prosecution, the defense, hey, the molding didn't work. This is not someone who's destroying evidence. This is someone who's reporting out, honestly and candidly, the molding on this one didn't work. But here are my findings. Same with Dr. Eric Smith, the two-mark analyst from the FBI that the La Plata County Sheriff's Office asked for assistance, says splicing cutting action was either a two-mark or something from the wild. You should ask a forensic anthropologist. And you have, ladies and gentlemen. And you've heard loud and clear, these injuries were not caused by an animal. These injuries were inflicted by this man. Defense counsel stressed in his closing that the defendant only had 14 hours to kill Dylan Redwine. That's a heck of a long time, ladies and gentlemen. And he actually had much longer. He had 10 days before anybody started to really look at him as a suspect and before any tracker was put on his truck. And then he had months later into 2013. He's even seen by Mike Hall coming down Middle Mountain Road in April. What is he doing up there? So counsel's right. He only had 14 hours, but he also had a lot more time than that. Counsel continues in his closing argument to say it's Mother Nature. And if Mother Nature was sitting here on trial, she would say, have you looked at that guy? Because all the evidence points to him. It is not a creature from the wild. And we know that from Heather Johnson, Drayton Harrison, the animal experts. Also, the defense expert, Jerry Apker, he agrees with them. It's very unlikely an animal would ever attack someone. You heard the statistics from them. If you're out on our trails, you're probably feeling even more confident than ever than after hearing how few people this actually happened to over the last 120 years. And Jerry Apker, the defense witness, said it's very unlikely that a coyote would go all the way around up to Rudman Park. It would not happen. That's the defense witness telling you that. He's being honest with you. The bears, they're hibernating by this time. And their digestive system slows down in mid-October. So even if they're awake, they're not eating, let alone attacking someone Dylan's size. And they don't go up Middle Mountain Road as much as they're looking for places people live. Garbage cans, scraps they can find, places where there are people, which is the exact place the defendant is not looking to dump Dylan's body on November 18th, 2012, into the early morning, about hours from November 19th, 2012. And here's the thing. When we talk about animals, before you start talking about animals and jury deliberations, ask yourself, but wait, what was Dylan doing up there? Because for all the talk in the defense closing about animals, none of which is supported by the wildlife experts, none of it. But for all the talk about the wildlife, what was Dylan doing up there? He's a boy who's thrilled to see his friends. There's no reason to go the opposite direction up Middle Mountain Road. It is away from civilization. It's away from his friends, from everybody he actually wants to be with in the Viaceto Bayfield area. So before you start talking about animals, remind yourself that no animal went into the living room, left Nickelodeon on the TV, snatched Dylan off the couch, dragged him out of the house, and dragged him up to the First Remains Site. The animal theory is even to be considered. What was Dylan doing up there? He doesn't hike. He would have called him and texted and all the things we've talked about. He's only up there because that's where the defendant dumped him. And if there's some bear that took Dylan, the bear, smarter than the average bear, he's walking around with Dylan's backpack on, using his cell phone and carrying his stuff. That is not reasonable. That is not supported by the evidence. That is not reality. That is what they want you to buy. Because that's the best thing they got to sell you. But it's not true, and it's not reality, and it's not reasonable. They talk about the scavengers. Dylan's body was fed on by scavengers. The evidence shows us that. We all know that. But they didn't inflict the injuries, peri-mortem, that killed Dylan. The skull fracture from blunt force trauma, and the cuts from a sharp force instrument. Counsel talked about Dr. Anderson. The one thing I would really highlight about Dr. Anderson, who's got a lot of knowledge and experience for Southern Arizona, but he's right. You should rely on a local forensic anthropologist in making these decisions. The one part of Dr. Anderson's testimony where it's probably memorable to you because he just sort of fell apart and told the judge he wasn't going to answer questions and it wasn't relevant, was when I showed him the sock. He was sitting up there, and he's like, oh, coyotes eat tennis shoes all the time. Da, da, da. I said, but take a look at the sock. And he realized he didn't have all the facts that you do. And he was sitting on the wrong side of justice in this case. Because a coyote doesn't take off a kid's sock. Toes from both feet were eaten. We know that from the forensic anthropologist. Toes from both feet were eaten. And there's an exhibit in evidence that shows the different skeletal parts of Dylan that were recovered. There's toes from the right foot, toes from the left foot, and the scat that was found there. This sock doesn't have a single mark on it from an animal. That's more consistent with someone who's dumping Dylan's clothing over the side of the trail. His shoe is chewed through, it's leather. Canids go after leather. But what's with the sock? What's with the sock is dumped there, and Dylan wasn't wearing it. And that's why Dr. Anderson started to struggle on the witness stand. In addition to forgetting that there was a 4-year study at his lab that showed the skull was recovered 88% of the time. That was a 4-year study at his lab. Proof beyond a reasonable doubt. So counsel in his closing on behalf of the defendant says there's a banana sticker there. This is a great example for you to think about as you talk about what's reasonable or not. The banana sticker is either the result of an old banana peel being picked up at the crime scene as they're picking up everything and putting it into the bag, and when they're going through the stuff later, including tiny little articles of Dylan's clothing, the banana sticker from the banana peel gets stuck on the shirt. That's one possibility. The other possibility is there's some killer out there who killed Dylan and how they met up on Middle Mountain Road. He killed Dylan, took careful steps to cover his tracks, then stopped, ate a banana, and tossed it down, and took the sticker and put it on Dylan's shirt. You will evaluate what's reasonable, ladies and gentlemen. There were banana peels recovered from the scene, along with the tiny little fabrics of Dylan's shirt, and when you put it back together, it's the black T-shirt, the Chicago White Sox T-shirt that you saw in the picture with Dylan and his grandmother. Karen Alexander, the defendant's former girlfriend, came in and testified earlier this week. She testified that everything she was going to describe to you happened in 2012, the Labor Day before Dylan went missing. And coincidentally, they were playing football, roughhousing, he was watching Nickelodeon. He also happened to bleed profusely and bleed right in the area where she thought, mistakenly, that blood had been identified by CBI while sitting on the couch. Except she hit the wrong spot. And most importantly, as much as she tried to convince you that this was true and that all these exact facts she was providing were from 2012, the extensive investigation provided by the sheriff's office completely disproved it and showed her to be a complete someone who doesn't tell the truth. It was 2011. It was more than a year and 3 months earlier. And the other facts that she tries to give you are all fake, ladies and gentlemen. Ask yourself, that's not about her being a bad person. How did she end up on the witness stand for this guy trying to tell you this story? It's because he's guilty. She comes in and adopts the best possible version of events for the defense and says it happened in 2012 and then goes down in flames because it was actually 2011. But that's not because she's a bad person necessarily. That's not because she just wanted to show up in court and lie under oath. It's in part because she's doing it for a guy who knows he's 100% guilty of knowingly killing Dylan. It's no coincidence when the girlfriend shows up and tells you a story that you realize is completely false. These convenient facts she offers, which were disproven entirely, are because he knows he's guilty. In some ways, she makes your guilty verdict easier because you know, you're smart people, you know when you're being played. The defense attorney referenced the group outside the defendant's home, whether it's a protest gathering. Quite frankly, I suggest the word doesn't matter. They're outside the defendant's home in February. Call it a protest. They're out there in February protesting. The defense put in the photograph. Look at the signs they're holding. And ask yourself, what are they demanding of the defendant? The answer is answers. They're saying, where is Dylan? Speak up. Where is Dylan? We know that you know where Dylan is. We, your children, we, your ex-wives, we, law enforcement, we, the experts, we, the jury, know what you did. Tell us. But what's really telling about this, actually, is that the defendant takes a picture of them. This is 2013. And he keeps the picture all these years. He keeps the picture all these years. Even though he's taken no action to call Dylan, text Dylan, sign Dylan, he keeps that picture. He throws these pictures in the trash.
Again, the jury will need to use its collective memory to remember what the facts are and make your decision based upon that and the law that I've provided. Go ahead.
Thank you, Your Honor. He throws that set of pictures in the trash. He throws that set of pictures in the trash. Ask yourself as a parent, when does a parent throw out pictures of their kid? Then add a word. When does a parent throw out pictures of their dead kid? It's when you killed him and you know what you did and you don't want to be reminded of it every single day. Otherwise, you do what anyone else in the world would do. You cherish these. These are the things you keep forever. If you know anybody who has kids, you know that you keep these pictures. If you can imagine someone having a kid who's dead, these pictures never let go. He throws them in the garbage, but he can't wait to show you the protest picture and to point out the people in the picture and to again blame them. When we're here because he killed Dylan Redwine. It's been a long 9 years. And it's been a long 5 weeks for you. And I just want to stop for a second and tell you how much we appreciate all your time, your attention, your diligence in doing your duty for this case. And in just a few minutes, you're going to have the case, and you're going to be able to deliberate and talk about it. And the trial's gone on for weeks, but This actually started in November of 2012. Every step of the way, the defendant has done everything he can to avoid the moment that's coming, to avoid responsibility, to avoid accountability. We're here today because how many people responded when Dylan's mother called the house? Because how many people responded and did their duty when they realized there was a child who was missing? And in the first few months, that's what this was. This wasn't a criminal investigation. This was volunteer, search and rescue, family, not the father, searching, looking, trying to find a missing child. Picture that time, that effort, people doing their very best, doing their duty to find Dylan, and then once they realized he'd been killed, to investigate, prosecute his killer. And in a few minutes, I'm going to be asking you to do your duty as a jury of his peers and to hold him responsible and accountable. Counsel asks you, why is this courthouse here? This courthouse is here because this is where we come to do justice. This is where we come to do the right thing. This is where we come when people harm others, which happens, even in a beautiful community like this. It happens. No community is immune. And murders almost always happen behind closed doors. And we look to the evidence to hold the killer accountable. And there's a mountain of evidence standing behind us here. And it all points to this man being the killer. So we come to this courthouse with justice to be done. And we ask you to do that, ladies and gentlemen, by relying on your common sense and your life experience. It's been a long 5 weeks here. You've heard a lot of evidence. I'm not going to get into the DNA evidence, and I imagine you're breathing a sigh of relief in your own mind when I say that. The only thing I'm going to say about DNA is counsel wants you to think a lot, talk a lot, ponder a lot about the weight of the DNA swabs. I would just ask you to rely on the expert called by the defense on DNA, who when asked, Ms. Kramer, is there enough weight there to develop a DNA profile? Yes. Can you determine by the percentages who the contributor of blood is? No. But you can do DNA profiles off that weight? Yes. That's the defense expert. So while I recognize we spent a lot of time talking about weight in the defense closing, rely on the defense expert. But there was certainly enough weight there. You have the experts, but you also have your own common sense and life experience. Knowingly killed Dylan Redwine. Knowingly. Knowingly is flying to a violent rage and hitting someone in the head hard enough that you kill them. We've all hit our heads. We've also seen kids hit their heads, and we have that moment of terror when we think something's actually happened. And then 5 minutes later, everybody's okay. Like Dr. Kirkman talked about, the force that's required to actually kill someone by hitting them in the head. That's what he did, Dylan Redwine. And all the evidence points to that. Knowingly is trying to get rid of his body. Knowingly is cleaning up the blood. Knowingly is putting knife into bone. No one says it happened in the living room. But we know it happened. He put a knife hard enough into his son that he was able to cut bone. Look to the experts. Follow the experts. But follow your common sense that knowingly is hiding a body. Knowingly is dumping a body. At its core, this is a simple and tragic case. You're almost done. You're going to reach the right verdict in this case. And you're going to find the defendant guilty. And then you'll be able to go back to your regular lives. Let's assume for a moment tomorrow night, you're able to go out and relax. And you could finally talk to your loved one about what you were doing here for the last 5 weeks and what you heard and why you found the defendant guilty. And this is what you would say. Mark Redwine was the last person seen with Dylan. Mark Redwine was the last person with Dylan when he was heard from by anybody in the universe. He had the opportunity and the reason to hurt Dylan. Whether it's the poop pictures, whether it's a fight they're having, an argument, he took his head, Dylan's head, with enough force to kill him. and made cuts into his bone. He killed Dylan. You'll tell your loved one. He's also guilty because he had Dylan's blood in his house. And there was DNA down there. And he had the smell of a human body, a human remains dog, alerted on multiple spots in the same room where they were sitting, that same room that I just talked about where there was blood found, where there was tension and anger, and they were roughhousing. And the smell of human remains in his truck. Counsel showed you that picture of the fingernail. You can go back and check your notes. That fingernail is actually found in the front driver's seat area. The dog hid on the back seat. So as much as we'd like to believe that human remain dogs are alerting on fingernails, which I would submit to you doesn't happen, that fingernail is not even in the right place for that argument. That's in the front driver's seat. The driver's fingernail is in the way. The dog's alerting to the back and to the cab of the trunk. And when you're telling your friend about why you reached the verdict you did in this case and held this guy responsible, you'll be able to tell him or her how incredibly evasive he was and misleading and suspicious, all of which is consistent with killing Dylan. We'll talk about how close the remains were found to the defendant's home. Not just in one location, but Dylan had no other reason in the world to be in, but in two separate locations. And what that means in terms of the defendant trying to get rid of Dylan's head, because it shows injury. And that the defendant was the only person who had any reason to take Dylan's belongings after he killed him. The only person. And he ends up with one on him, the bank card. He took Dylan's stuff. And he has one of those items. And we'll talk about the remains showing injury to Dylan that resulted in his death. On November 18th, 2012, Elaine Hall experienced a parent's worst nightmare. The worst nightmare a parent can have. When you send a text at 10:09, as Elaine did on the night of November 18th. How's it going, son? You okay? She's been waiting 9 years for her son. She's been waiting 9 years for a response. Because this guy killed her son. And this is the response she gets now. No. Your son was not okay. Mark Redwine killed him. And should be held fully responsible and fully accountable, ladies and gentlemen. He is guilty of second-degree murder and child abuse resulting in death. Thank you.
All right, instruction number 26. The bailiff will now escort you to the jury room, where you will select one of your members to be foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form that you may agree on, according to the rules that I'm about to explain. The verdict for each charge must represent the considered judgment of each juror. It must be unanimous. In other words, you must agree to all parts of it. This requirement also applies to any determination that you make in response to a verdict question that you conclude should be answered. Only one verdict shall be returned, signed for each count. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching the verdict, and if required by a verdict, answering any verdict questions, you will inform the bailiff, who will in turn notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 2 verdict forms. When you have unanimously agreed upon your verdict, you will select the option on each form which reflects your verdict, and the foreperson will sign the verdict forms as I have stated. Similarly, if you conclude that the verdict question should be answered, you will select the option on each verdict question which reflects your unanimous decision, and your foreperson will sign each verdict question form as I have stated. I will now read you the verdict forms. You must not draw any inference based upon the order in which I read them. The verdict forms which you will receive read as follows. Jury verdict, count number 1, murder in the second degree. 1, we, the jury, find the defendant, Mark Redwine, not guilty of count number 1, murder in the second degree, and the lesser included offense of criminally negligent homicide, a place for the foreperson to sign. 2, a place to make a mark, and then we, the jury, find the defendant, Mark Redwine, guilty of count 1, murder in the second degree, a place for the foreperson to sign. Below that is another place to make a mark, and we, the jury, find the defendant, Mark Redwine, guilty, count number 1, of the lesser included offense to count number 1 of criminally negligent homicide. The foreperson should sign only one of the above. If the verdict is not guilty as the offense charged, and the lesser included offense, then one above should be signed. If the verdict is guilty as to the offense charged or a lesser offense, then the offense listed in 2 above, which the jury has unanimously agreed as to the guilt of the defendant, should be marked with an X and signed by the foreperson. While the jury may find the defendant not guilty of both the offense charged and the lesser included offense, the jury may not find the defendant guilty of both the charged offense and the lesser included offense. Jury verdict count 2, child abuse. 1, we, the jury, find the defendant, Mark Redwine, not guilty of count number 2, child abuse, and the lesser included offense of child abuse committed with criminal negligence, a place for the foreperson to sign. Number 2, we, the jury, find the defendant, Mark Redwine, guilty of count number 2, child abuse, and a place for the foreperson to sign. Below that is we, the jury, find the defendant, Mark Redwine, guilty of count 2, child abuse committed with criminal negligence, a place for the foreperson to sign. We, the jury, find, with respect to the verdict question for this count, as follows. 1, did the child abuse result in death? Answer yes or no. A place to mark yes, and a place to mark no, and a place for the foreperson to sign. The foreperson should sign only one of the above. If the verdict is not guilty as to the offense charged and the lesser included offense, then one above should be signed. If the verdict is guilty as to the charged offense or the lesser included offense, then the offense listed in 2 above should be signed. 2 above, which the jury has unanimously agreed as to the guilt of the defendant, should be marked with an X, signed by the foreman, and the jury should answer the verdict question. If the verdict question is answered, the foreman shall sign the verdict question. While the jury may find the defendant not guilty of both the offense charged and the lesser included offense, the jury may not find the defendant guilty of both the charged offense and the lesser included offense. So, now is the time that you'll get to go back and deliberate. I need to know if everybody's feeling okay. Is there anybody who does not feel like they can deliberate on this case? Looks like everybody's feeling well. We have 2 alternates remaining in this case, and they are Mr. Grothbend and Ms. Rios. So I'd like the 2 of you to stay briefly, and then we'll let you go downstairs and pick up your stuff if you need to. I need to give you an instruction and tell you what's going on from your end of it. Everyone else will go down and deliberate. You can decide how long you want to stay tonight. If you want to leave at 5 like you've been doing, that's fine. Come back tomorrow. You can set the time tomorrow that you want to come back. If you want to stay late tonight, you can do that too. If you do stay over the lunch or dinner hours, we will provide you with a meal. So Cindy, I need for you to come up so I can swear you in first. Raise your right hand. Do you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury together in some private and convenient place, that you will not permit any person to speak to them or speak to them yourself, unless by order of the court, except to ask them if they've agreed upon a verdict, and that when they've agreed, you will return with them to move forward? Thank you. We will, there's a lot of stuff up here that you have to have downstairs in the jury room. We will bring that down to you along with the original verdict forms. So with that, everybody rise for the jury. And everyone but Mr. Grothbend and Ms. Rios can go downstairs. Okay, we can be seated. No, Mr. Rios was not displeased with finding that out. However, you're really not off the hook yet. I know it can be disappointing that you're not down there because you spent all this time, and you can be happy about it too. But until there's a verdict reached by the jury, you guys are still on the hook in case somebody gets sick or there's a problem. You may have to go in and deliver it. And so for that reason, we should have your phone numbers. I'm sure that Cindy does, and if not, make sure she does. But for that reason, you're still under my admonitions not to discuss this case with anybody else, even though everybody's going to want to now that you're not down there with them. But you can't discuss the case with anybody. You can't initiate or post or respond to anything on social media. In fairness to the parties of the lawsuit, if you get called, you have to decide the case down in the jury room with all the other jurors. Do not permit any third person to talk to this case about it without, and if they do persist in doing that, please let me know. Don't talk to any of the witnesses or lawyers or the defendant anywhere. Don't talk to them. Don't gather any information on your own. Do not engage in any outside reading. Do not attempt to read any cases. Don't read about the case still in the newspaper. Obtain information about it on the radio or television, the internet, social media, or the media source. Do not in any way try and learn about the case until a verdict is reached. I don't think we've ever had anybody come in and help. I have no idea how long the jury's going to be on this. It could be quick. It could be into next week sometime. So there's really a chance that you guys could be called on to delivery. Assuming that you're not, however, I do have a final concluding instruction for once we call you and let you know that you don't have to come back and read this from my admonitions. You have now completed your duties as jurors in this case and are discharged with my thanks. The question will arise at that point whether you can discuss the case with lawyers, defendants, or other persons. I'm going to instruct you that whether you talk to anyone or not is entirely your decision. It's proper for others to discuss the case with you after you tell you that you can. And you may talk to them, but you don't have to. If you talk to them, you can tell them as much as little as you want about what happened during this case, or if you end up actually deliberating anything that influenced your decision. If anyone persists in discussing the case over your objection, it becomes critical of your service. Either before or after any discussion is begun, please report that to me and I will deal with it. So what we'd like you to do now is go downstairs, get whatever you need, and go about your day. As soon as we know what's going on, we'll give you a call. All right? Thank you very much. Everybody right through the alternate? Yes, we do. Hold on a second. I'll go down with it. Okay. We're just going to keep you away from everybody else. I'll just go down and see what you're saying. All right? And so with that, we'll be in recess. Thanks, John.
Series.